So we're still talking about the Kentucky Constitution. Never stop. Always Kentucky Constitution, Constitution, Kentucky. YouTube Kentucky Constitution. All my videos are coming up. So hopefully this actually gets passed around, distributed. Everybody can do these lessons on their own. As long as I can, I'm gonna come up with the questions. If you can do the questions, then you've learned the material, right? You can learn through the lectures. You can learn any way you want to. But if you pass the test, you can pass the test. So. Carrying on, so these are lectures, and then the discussion questions should be coming up hopefully towards the end. This is just so chock full of data-rich material. I just like to get it actually all documented. So, carrying on. The first 26 sections of the Kentucky Constitution constitute the Bill of Rights. The language of these sections were taken largely from the Pennsylvania Constitution of 1790, which we already know about, but borrowed some verbiage from the Declaration of Independence and Virginia Declaration of Rights of 1776. Framers of the Third Constitution and the current Constitution added one section each. So the Third Constitution and the current one, so the Fourth Constitution, the Third Constitution added Section 2, which denies absolute and arbitrary power for anybody, and even in the majority of a republic, right, which was designed to make sure that the slaveholders would be recompensated for their slaves. And then the current Constitution, 1891, they added Section 25, where they outlawed slavery. And so that completely undoes Section 2, so that sort of was prohibition in its repeal. The framers of the Third Constitution added subsections to Sections 1, authorizing the legislature to enact laws to prevent persons from carrying concealed weapons. So the first section says you have a right to bear arms, and then it says you have a right to bear arms as long as it's not being concealed. So I guess everybody had a gun in the days of the Wild West, when Kentucky was the Wild West. As long as your gun was outside, then people knew that you had the gun, and therefore it wasn't, if it was concealed, then at any point you could just pull it out and start shooting. Why you concealing it? Why you keeping it hidden? But if you kept it out, then it was because you just carried a piece, and that was just how it was. So the framers of the Third Constitution added subsections to Section 1, authorizing the legislature to enact laws to prevent persons from carrying concealed weapons, and Section 11, which authorized the legislature to enact a general change of venue law. So if the county court system had a conflict of interest, then your trial would be moved to another county court, and it would be tried in a different place. So that's Section 11. You have the right to change the venue, and there's also in 1988, voters ratified a legislative addition to Section 19. So this is the Bill of Rights. These are all of our freedoms. We got a right to a jury trial, right to a change of venue, right to carry weapons as long as it's not concealed. Section 19 it says ratified a legislative addition to Section 19. They added another addition. So this has been changes to the Constitution. Has been usually through amendments, and so they ratified a legislative section. The legislation changed the Constitution without going through the voting process, so the legislature could just change the Constitution whenever they feel like it. And they said a legislative addition in effect prohibiting strip mining, but it says the voters ratified it. So actually, I'm getting this all confused. It's a referendum, so I'm not sure if the legislation can actually insert language. If they can, then that would be the best way to change it, but only through amendment and constitutional convention. So in effect, they prohibited strip mining under the broad form deeds unless the mining is specifically agreed to by the parties to the deed. That was in 1988. The Kentucky Constitution's Bill of Rights guarantees all the freedoms guaranteed by the U.S. Constitution's Bill of Rights, and in some instances expands those freedoms. For example, the Kentucky Supreme Court has found in Section 5 guarantees the right of religious freedom, together with Section 189, which prohibits the use of public school money to support religious schools, a higher wall separating church and state. In Fannin v. Williams, 655 South SW2D 480, 1983, the court held unconstitutional a statute that authorized the state librarian to supply textbooks to children in parochial schools, a church-state relationship that had been upheld by the U.S. Supreme Court in a case concerning the First Amendment to the U.S. Constitution. So in Fannin v. Williams in 1983, they said that the state librarian did not have to give textbooks out to church schools, to Muslim schools, to Islamic schools, to satanic schools to Pastafarian schools. In 1992, the Kentucky Supreme Court cited language in Section 1 that referred to inalienable rights, the right of enjoying their lives and liberties and the right of seeking and pursuing their happiness, to find a right to privacy that was violated by a state statute that punished consensual deviate sexual intercourse with another person of the same sex. 6 years before this decision, the United States Supreme Court had upheld a similar state statute that was challenged under the federal Constitution in Bowers v. Hardwick, 478 U.S. 186, 1986, a decision that was not overruled by that court until 2003 in Lawrence v. Texas, 539 U.S. 558. The Kentucky Supreme Court also found in Section 1 a natural right to pursue a legitimate business or profession, which was violated by Kentucky's compulsory medical malpractice insurance statute. The framers of the Third Constitution added Section 2 to the Bill of Rights as an attempt to prevent a future legislative majority from emancipating Kentucky's slaves without compensation to slave owners. 1850 strengthened the slave fucking statutes. So 1850 was a regression when it came to slavery. And more recently, non-slave owning property owners have found the section's language, absolute and arbitrary power over the lives, liberty, and property of free men exists nowhere in a republic, not even in the largest majority, to be a more effective weapon against certain regulations of the economy than the United States Constitution. Thus, the Kentucky Supreme Court used Section 2 to invalidate Kentucky's milk marketing law, which in an effort to prevent monopolies and unfair practices in the sale of milk and milk products, prohibited retailers from selling milk below cost. But you can't do that. You can't have absolute and arbitrary power over the lives, liberty, and property of free men exists nowhere in a republic, not even in the largest majority. The Kentucky Supreme Court has ruled that Section 3 of the Bill of Rights, which declares in part that all men, when they form a social compact, are equal, together with Sections 1, 2, and 59, embraces the Equal Protection Clause of the 14th Amendment to the United States Constitution, and might provide greater protection of individual liberties than the federal equivalent. The Kentucky Supreme Court has generally embraced a generous view of Section 8's guarantee of freedom of speech and press. For example, see Ashland Publishing Company v. Asbury, 612 SW2D 749, 1980. But lately it has taken a less libertarian view of freedom from illegal search and seizure, duplicating somewhat the recent trend of the U.S. Supreme Court. For example, see Estep v. Commonwealth, 1983. The Kentucky Supreme Court also has not enlarged the freedom from self-incrimination beyond that which is guaranteed by the U.S. Constitution. Resembling the Federal Bill of Rights, Kentucky's Bill of Rights prohibits double jeopardy. Section 13 guarantees the right of bail and habeas corpus, the right to not be imprisoned. Section 16 restricts imprisonment for debt. Section 18 standing armies prohibits standing armies. Section 22 guarantees free immigration out of the state. Section 24, the right to trial by jury. Section 7 prohibits ex post facto laws and laws that impair the obligation of contracts. Section 19, the Kentucky Supreme Court has upheld the amendment to Section 19 that prohibits strip mining under the broad form deed unless such mining is specifically agreed to. The Kentucky Court of Appeals ruled that Section 4, which gives the people the right to alter, reform, or abolish their government in such manner as they may deem proper, authorized the legislature to establish in 1964 the Constitutional Revision Assembly. The Constitution Revision Assembly. That drafted the voter rejected Constitution in 1966. Section 14 of the Bill of Rights states that all courts shall be open and every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law, and right and justice administered without sale, denial, or delay. The Kentucky Supreme Court has ruled that this section, together with Section 54, the first found in the current Constitution, which states that the General Assembly shall have no power to limit the amount to be recovered for injuries resulting in death or for injuries to personal property, and Section 241, also first found in the current Constitution, which enlarges the right to sue for wrongful death, serves as a barrier to statutory tort reform and substantially enhances the rights of those who are suing to recover damages for personal injury or wrongful death by prohibiting the legislature from abolishing or diminishing rights to sue that existed before the adoption of the current Constitution. For example, the Kentucky Supreme Court invalidated a statute that made it more difficult to secure punitive damages in personal injury cases on the grounds that the legislation sought to diminish a right established before the adoption of the current Constitution. Sections 27 and 28 of the Constitution provide for the separation of powers. Citing these sections, the Kentucky Supreme Court invalidated most of the legislation that empowered the Legislative Research Commission to veto administrative regulations issued by the governor to approve or disallow gubernatorial orders reorganizing the executive branch and to nominate persons for gubernatorial appointments to certain executive agencies. The statute also authorized the Speaker of the House and the President pro tempore of the Senate to appoint members of certain executive boards and agencies, appointed certain legislators to executive boards and agencies, and designated the Legislative Research Commission as an independent agency of state government, thus making it exempt from the governor's control and reorganization. So that's section 27 and 28, right? So sections 29 to 62 concerns the legislative branch, which has been a subject of another significant rulings. In 1900, the Court of Appeals invalidated Governor William S. Taylor's attempt amid the turmoil after the controversial gubernatorial election of 1899 and the assassination of the Democratic candidate William Goebel to adjourn the General Assembly to reconvene it in London, Kentucky. The Court of Appeals ruled that the governor had encroached on the prerogatives of the General Assembly as guaranteed by sections 36 and 41, both of which in part concern legislative adjournment. In the same case, the Court of Appeals, citing section 40, required each legislative house to keep and publish a journal of its proceedings, rejected a petition alleging that the legislative journals had been tampered with in order to support J.C.W. Beckham's claim to the governorship. The court decided that the judiciary must presume that entries in the legislative journals are valid and cannot launch an inquiry regarding their integrity. As an example of the judiciary interpreting the Constitution in a flexible fashion to adapt it to modern times, the Court of Appeals ruled that revenue bonds, interest-bearing warrants, and holding company bonds that are not guaranteed by the full faith and credit of the Commonwealth, but are funded solely by the revenue generated by the projects the bonds are sold to finance, do not constitute debts covered by Section 49, which limits the amount of legislative contracts of indebtedness to $500,000. In Stevenson v. Woodward, 2005, the Kentucky Supreme Court ruled that Section 38, which empowers each legislative house to judge the qualifications, elections, and returns of its members, does not authorize the state Senate to seat a candidate who received the most votes in a contested election where the candidate was not qualified because she had not lived in the senatorial district for the required number of years. Section 59, which prohibits specific kinds of private, local, and special legislation that preoccupied the legislature before the adoption of the current Constitution, has been the subject of more published appellate court adjudication than any other section applying to legislative powers. The Kentucky Supreme Court has declared that the primary purpose of Section 59, so what is Section 59? Is to prevent special privileges, favoritism, and discrimination, and to ensure equality under the law. The court has held that this section, together with sections 1, 2, and 3, invalidated a statute of limitations that immunized from personal injury liability persons who designed, planned, supervised, inspected, or constructed improvements to real property after the expiration of 5 years following the completion of the improvement. The framers of the current Constitution added Section 61 during the revisory session of the convention in response to complaints from temperance forces that the new Constitution was pro-liquor because Section 59, subsection 27, forbade the General Assembly from enacting local or special laws authorizing local option elections. Section 61 empowers the General Assembly to enact a general law that authorizes such elections. The Kentucky Court of Appeals strictly enforced Section 63, which prohibits the creation of counties less than 400 square miles in area. Zimmerman v. Brooks, 1904, it invalidated the creation of Beckham County because its area was less than 400 square miles. Section 64 which requires approval of a majority of all the legal voters to move a county seat. Hogg v. Baker, 1895, in Section 65, which makes territory stricken from a county liable for its share of the indebtedness of the country from which it was stricken. Whitley County v. Wood, 1914. So, more sections of Kentucky Constitution coming up.